Good day, Crime Talk aficionados. We have another great show for you today. First, the DNA fight continues in the Bryan Kohberger case based upon some new motions. Karen Reed said she would cheer the OJ verdict if it was today. Lori Vallow, her trial continues. The Menendez brothers have a hearing, this day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And remember, you can check us out on any of your favorite podcasting apps. Before we get to the docket on this Friday, April 11th, let's do, a quick promo. That's right. Go to crimetalksearch.com. Sign up for that background subscription service today. When you have that subscription, which you can cancel at any time, you can do as many background searches as you desire when you have that subscription. And when you search an individual's name, a report is literally prepared while you wait, and it is then emailed to you. You can then get updates if any of that information changes, and it's going to have contact information, phone numbers, email addresses. It's going to have information about social media presence. Does this person have liens, judgments against them? Are they married? Are they divorced? Do they have a criminal history? Everything you want to know about somebody before they come into your life, or maybe you're just thinking, I need to check them out a little further and get them out of my life. So go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and open the record for April 11th. It's another Bryan Kohberger day because the Bryan Kohberger information just keeps coming. The DNA is what they're fighting about today. A couple of motions that were filed with the court, a couple really not relevant, but we'll start off with the least important. First, next, the notice of filing of defendant's Exhibit D1 in support of the objection to the state's notice of intent to use 404B evidence. As you may recall, at the motions hearing that had taken place on Wednesday, there was an issue about the stop of Bryan Kohberger and whether that should come in as 404B evidence. The big thing, basically, he wasn't wearing a seatbelt at the time. So that's not really a big deal. But the judge is going to decide whether there needs to be some redactions that need to be made, as well as a stipulated motion to seal Defendant's Exhibit 4 in support of their objection to the state's motion in limine, specifically the AT&T time advanced records. So what this document is basically an affidavit prepared by the defense expert as it relates to Cy Ray, the big cell phone expert, right, that was going to supposedly provide some information as it relates to an alibi, possibly. I mean, it's not really an alibi, but to say when the phone was off and when it wasn't, and maybe when it was just, in the mountains and you didn't get a good signal, something along those lines. All right. But the judge took great exception with the affidavit that had previously been prepared as it relates to Mr. Ray, because he basically was saying that the prosecution and the police officers, special agents handling the case, basically engaged in unethical conduct. And he says, based upon what was said by Mr. Ray in his previous affidavit, that's pretty serious allegations, and I didn't really see anything to back it up. And if those allegations are true, maybe people on the other side of the courtroom there could lose their law license over it. So you better back it up. So although we don't get to see these sealed exhibits, I do believe, based upon what we know so far and, years of training and experience, that is what the defense is filing, trying to gain a little credibility with the judge because, as you may recall, the defense says that these time in advance records were available. AT&T, through their people, signed an affidavit saying they weren't available this particular time period. The prosecution said, we would love to have had that information, but we didn't have it because it doesn't exist. Defense is saying, oh no, it exists. You failed to get it, right? And so that's more than likely what that affidavit is all about. Now, the next big thing is a thick one. It's a real thick one, ladies and gentlemen. And it is the notice of filing, the supplemental affidavit in support of response to defendant's motion in limine regarding inconclusive DNA. All right. Remember at the hearing just the other day, the defense said that the testimony about the DNA evidence under Madison Mogen's fingernails should be basically excluded because even the prosecution agrees that it's at best inconclusive. All right. And so there's a battle over the terminology. And so the state's expert in this particular case, Christian Westring, who has a PhD in biology from the University of Denver. That's right, the Harvard of the West. I say that because I went to the University of Denver, has prepared a big 25-page report. But I have done a summary for you so that we don't have to go through every single line of it, because a lot of it is frankly irrelevant. It would put everybody to sleep, and we don't want that. We want to save all the good, juicy stuff. All right. So this expert in regards to the DNA in the interpretation, like I said, it is prepared by Christian, Christian Westring, PhD. So let's just do a quick summary. The expert for the prosecution holds a doctoral degree in biology and has over 20 years experience in forensic biology, specializing in serological testing and DNA analysis. They have served in high-level roles, including laboratory director at Accredited Forensic Labs, director at Purdue University Center for Crime and Forensic, served as the quality manager overseeing the FBI quality assurance standards, and they are actively involved in developing forensic DNA standards through OSAC and chairing the Threshold Task Group. As you may recall, that's really what this is. It's about thresholds, and is it inconclusive? Is it excluded based upon the value, so to speak, the largesse of the DNA sample. Anyway, their expert says their extensive research, publications, and training programs in forensic biology, furthering establishing their credibility. Now, the key questions addressed in this thing are the definition of inclusion, exclusion, and inclusive in forensic DNA analysis. Inclusion. An individual cannot be excluded as a potential contributor to a DNA sample based upon a profile comparison. It indicates the DNA profile matches at all compared loci. Exclusions. An individual is eliminated as a contributor because their DNA profile differs from the evidence samples at or more one of the loci. And the exclusions does not necessarily imply non-involvement, and no biological material may have been left. Inconclusive, the definitive conclusion is inconclusive or exclusion, can be drawn due to insufficient or complex data, such as low DNA quantity, degradation, or mixture complexity. So then the next question is how do we get here? So I just want to show you when they run these DNA samples. All right, they run it through this test, right? And here is an allele report, and they'll say, okay, there's various alleles, and then they'll give it, a certain number based upon how high it is, and they'll say, that is a particular DNA at a particular loci. All right, and they'll say this is the loci at D16S539. It's high enough, and then they give other little numbers and stuff in there. It's kind of hard to explain. But then they will have, for example, these various locations, okay? And at these various locations, these are the areas where the DNA was found, various loci, all right? And then they'll look at the individual loci and they'll say, okay, this person is this, this, and this, all right? Simple enough. And they say, well, there's an X and a Y, so it's possibly an X or a Y, or an XX and a Y. But then they'll say, let's go to DS1358. Okay, that's the first loci on this particular one. And they'll say they get a 15, a 16, and a 17. Then they'll look at the known sample of that particular individual, and they say, well, he's got a 15 and a 16 at that particular allele. And so therefore, we can say that that's him. That's the defendant, right? And then the next one, there's another one there, and he's not a 17 in his known profile. So therefore, it's got to be a mixture, right? And so you go down the list, and then based upon whether it's a weak allele, whether there's a inclusive, so they can have a non-detected, they can have a weak allele, inconclusive, possible stutter as it relates to the machine, and then a possible allele as well. They do all these basically different calculations, and they'll say someone's either excluded, not excluded, it can be included. That's the way it goes. And like I said, just because even if somebody commits a crime, doesn't necessarily mean that their DNA is going to be there. Just because somebody commits a crime or touches something, like let's say, for example, I touched this and they came and swabbed it, they may say, well, he must have, Scott brushed against the little button on his K-bar swab. So there may be small enough there, but it's going to be so small that they can say, well, we can't exclude Scott because there's maybe one of those alleles that match and there's another one that could be there, but it's just not strong enough to say it's absolutely positively had to be Scott. Maybe Frank, the hardest working man in show business, the producer, comes by here and touches it as well, but we don't know his DNA sample, and so we have an unknown mixture, and it may be weak, and depending upon the mixture, how strong it is for one particular person's DNA, and the other one may be a little weaker because there's more of one of the mixtures or not, all affects DNA. So they go through this, and then the summary talks about why laboratories set different criteria. And they say that laboratories establish protocols based on internal validation studies, reflecting their equipment, reagents, and processes. And these studies define analytical thresholds, stutter filters, and likelihood ratios. And differences arise due to variations in instruments, software. For example, there's the STR mix and the true allele. And then you have the own individual lab policies. And then certain organizations allow flexibility, as there's no universal standard that mandates specific thresholds, leading to lab-specific ranges tailored to their validated data. So it doesn't mean that one lab is necessarily wrong. It just means their equipment, maybe it's a little more accurate. Maybe their standards call for, we can say that somebody is inconclusive at a particular level on the DNA scale. So say it's a 0.1 to a 0.5 is inconclusive, but 0.5 and above, obviously you're going to say that. So it's inconclusive, but it doesn't mean that they're excluded, because it could be lots of different things. It could be the equipment, it could be the sample, etc. And so then this report goes on and discusses the differences between the Idaho State Police Lab and the Cybergenetics, which uses the true allele analysis, versus the state, which does the STR mix. Anyway, the Idaho State Lab and the Cybergenetics analyzed the same DNA data from item 13.1, but they reached different conclusions due to their methodological differences. Anyway, the ISP lab used a global threshold of 75 RFU, which is relative fluorescence units, detecting 61 alleles across 22 loci, right? That kind of goes to this. Here's the allele report. Here's the loci. I don't know if you can see that. All right. But there it is. That's kind of what they're talking about. Detecting 61 alleles across 22 loci, concluding a mixture of at least 3 contributors based on 6 alleles at that specific loci of D18S51. Then the likelihood ratio was 0.0469, and that reported as inconclusive per the Idaho State Lab's protocol. Cybergenetics applied a lower global threshold of 1 RFU with a 15 RFU peak, right? We talk about peaks. And so there's different things where they say, ooh, that's a peak. There's a little subjectiveness there when it comes to, is that one that they can call as an allele, all right? And it concluded a mixture of at least 4 contributors based upon a loci at D18S51. Okay, so this lower threshold captured more level peaks, increasing the complexity of the mixture interpretation, right? So they were looking for there was more intense, so they found even more. I hope that makes sense. I'm trying to explain this the best I can. And so then they said instead of the state has 3, their lab has 4, the defense has 4, but the quality of it is so low, they're basically saying, we can't do it. So they increased the complexity of the mixture interpretation. Then they have the validation process. The Idaho State Lab conducted internal validation for the STR mix machine or software that they use, aligning with the international standards and guidelines, ensuring parameters, examples, they're talking about stutters, alleles, dropout, and that's reflected in their data. Cybergenics did not use the ISP-specific validation for true allele, relying on general PowerPlex and that particular software and their fusion parameters. This deviates from best practices, according to this expert, potentially affecting reliability when analyzing the data. So the interpreting factors, you have stutter parameters. The Idaho State used lab-validated stutter filters, while the Cybergenics may have used published or probabilistic models affecting allele calls. Then you have contributor estimation. The Idaho State Lab relied upon maximum allele count, while Cybergenic used mixture deconvolution, factoring in victim profiles, leading to a higher contributor estimate. So the difference, the mixture proportions, that's the difference in the estimating of the victim's DNA contributions. For example, Madison Mogen, as a major contributor, influenced the likelihood ratio calculation. What does that mean? The outcome. The Idaho State Lab's likelihood ratio of 0.0469 suggested limited support for Kohberger not being a contributor, but was reported as inconclusive per protocol. Cybergenetics analysis with more detected alleles provided stronger statistical support for exclusion, though exact likelihood ratio values weren't detailed in their report. So both analyses ultimately support Kohberger's exclusion. This is for the fingernail, but the likelihood ratio weight differs due to the above factors that we just talked about. And without Cybergenics ISP specific validation, the direct likelihood ratio comparison is less meaningful. So, the independent opinion on the Idaho State Lab results for item 13.1. The expert conducted the independent analysis using the color-specific analytical threshold 19-34 RFU. It validates the Idaho State Lab's negative controls, contrasting with their global RFU threshold. The mixture complexity for 13.1, the item, which everybody tested, yielded a full DNA profile consistent with a mixture of at least 4 contributors, including at least 1 male, based on a 1% male DNA from the quantification of the DNA cells. The locus D18S51 showed 6 alleles with alleles 12, 15, and 16, right? Just like I'm showing you here in this little chart, if you can see that. You got the allele, and then you got an 11, a 12, a 13, a 14, a 15, and a 16 here. This, by way of example, completely unrelated to the Kohberger case, if I didn't make that clear already. All right. So it showed on that particular loci, 6 alleles with alleles 12, 15, and 16 supporting additional contributors beyond Mogen and Gonsalves after accounting for a stutter. So what does it really mean? Madison Mogen cannot be excluded, 83% contribution. Kaylee Gonsalves cannot be excluded. Bryan Kohberger excluded as a contributor as his profile differed at multiple loci. And the statistical analysis using the LR Mix Studio, some software that they use, the expert calculated the likelihood ratios indicating Kohberger's profile is 5,000 to 101,000 times less likely to match item 13.1 than an unrelated person, depending on population. So it strongly supports exclusion. And the qualitative assessment alone was sufficient to exclude Kohberger as allele mismatches were clear, but the likelihood ratio provided additional weight. So then we have the agreement with Cybergenics, which is the defense expert team. And this expert for the state says the expert concurs with Cybergenics' 4 contributor conclusion and Kohberger's exclusion, reinforcing the lower threshold ability to detect minor alleles. And so the Idaho State Lab's inconclusive call with the likelihood ratio of that 0.0469 aligns with their protocols, but understates the exclusion as the reciprocal of 1 over 0.0469 or greater than 25. It goes on, basically says that the critique, the ISP's higher threshold of 75 may have missed low-level alleles, underestimating the mixture's complexity. Cybergenics' lack of ISP-specific validation limits a direct comparison, but their lower threshold aligns better with the expert's finding. Overall conclusion, the term inclusion, exclusion, and inconclusive are well defined by these regulatory bodies with lab-specific criteria reflecting internal validation and operational needs. So the Idaho State Lab's conservative threshold and validated through the STR mix analysis contrasted with Cybergenics' lower threshold and non-validated true allele approach, leading to different contributor estimates and the likelihood ratio weights. Both supports Kohberger's exclusion, but Cybergenics' analysis aligns more with the expert's findings due to increased sensitivity. His independent opinion, item 13.1, the scrapings under Madison Mogen's fingernail is a complex mixture of at least 4 contributors, with Mogen and Gonsalves as major contributors. Kohberger is excluded, supported by both quantitative mismatches and strong likelihood values. The Idaho State Lab's inconclusive call was protocol compliant, but conservative, while Cybergenics and the expert analyses provide clearer exclusions. The report emphasizes the importance of the lab-specific validation, highlighting a procedural gap in Cybergenics' approach that could affect reliability in court. The expert's use of the color-specific threshold demonstrates a rigorous, data-driven approach, balancing sensitivity and artifact avoidance. The additional information was needed as the document is comprehensive. So what does that mean? Yes, just as the defense said, Kohberger is more than likely excluded from the DNA sample underneath Madison Mogen's fingernails. We got that. But the Idaho State Lab is not wrong in their analysis. I know that was a lot. I know it's kind of confusing. Everybody just wants to think, well, there's DNA. He had to have been there. It doesn't necessarily mean that. And if it's low quality, but at that particular allele, they say I'm just using this example. This is not from the Kohberger case. I don't have access to any of that, but this is an example of an allele report. They say at this particular allele, we'll just say D1S1248, there's an 11, a 12, a 13, a 14, a 15, and a 16. All right. But what they're saying then is in Kohberger's case, let's say he's a 9 and an 8. It couldn't be him. So therefore, they're saying exclusion. The state's expert is saying the defense experts were a little more sensitive. That's why they got 4 people versus 3, but they don't necessarily disagree with that result. It's just a different way of coming to the same thing. I still think it's wide open for the prosecution to explain what they did, right? And why it is as such. And their expert will admit that I don't necessarily disagree with their lab report at all, but we just got to a different analysis based upon software, based upon standards, etc. So what that means is it's not Bryan Kohberger's DNA under the fingernail. I know, kind of a long way to get there, but that's really what it means. So, but the prosecution can still bring it up and try to explain it to the jury, but the conclusion is there. Frankly, I would think the prosecution would probably want to stay away from that, or we looked at it and, basically it's inconclusive or should be excluded. Either way, it helps Bryan Kohberger because one of the alleles doesn't even match, the loci doesn't match that particular allele. So there you go. Whew. Next. Karen Reed. Jury selection will continue on Monday in the murder case of Karen Reed. 16 jurors have been seated, but the judge is now looking for an additional 2 jurors to sit as the alternates in Karen Reed's second murder trial. 12 of those obviously will deliberate. 6 will serve as alternates. Now, Karen Reed has been a busy woman. She gave an interview with Vanity Fair. Yeah, the fashion magazine kind of stuff and lifestyle magazine. Anyway, we've learned obviously that she has expanded her legal team of David Yannetti, Alan Jackson, and Elizabeth Little, adding obviously Robert Alessi of New York, Victoria George of Massachusetts, the juror from the first trial, and 9 law students who are acting as law clerks, including a woman by the name of Sophia Hunt, who recently served as Harvard Law Review's president, and Abigail Rozovsky, a former Fulbright scholar. Reed has already sunk 7 figures into her defense, liquidating her retirement funds, selling her house, and relying upon donations. All 11 of her additions are working pro bono. The elected district attorney obviously has enlisted Hank Brennan, one of the famous mobsters Whitey Bulger's defense lawyers, to act as the special prosecutor for the government. Now, Brennan has taken more of a proactive approach than his predecessors in the first trial there, specifically Adam Lally. Last month, Brennan tried to obtain text messages between Reed and Yannetti, arguing that Reed had sacrificed the attorney-client privilege by discussing her conversations with her lawyer in interviews. Now, the judge denied that. But then he also sought private conversations between Karen Reed and Aidan Kearney, the blogger known as Turtle Boy, contending that they would prove consciousness of guilt. Brennan argued that motion before a different judge who's handling that case. And after Reed and her lawyers marched into the courtroom, did somewhat dramatically, Mr. Brennan said to the judge, "I'm not sure why they're being joined by Miss Reed's team unless they have standing in this particular case," which they didn't. Miss Reed, as you may recall, was throwing daggers with her eyes at Mr. Brennan, and Mr. Brennan was ultimately given access to those messages, where some people, obviously we have not all seen those, but some people are suggesting that maybe there is something in there that's going to make her look bad. Because a lot of people think, and I kind of think, the defense doesn't seem to have their pep in their step like they did the first time through. Anyway, Mr. Brennan has also found himself on the defense as well. In the last 6 months, Reed's team received 2 new batches of security footage from the Canton Police Department, where she claims that law enforcement tampered with her car, the alleged murder weapon, and that's obviously where the plot to frame her came about. Now, Reed alleges that her taillight was broken at the Canton PD, with fragments later planted at the crime scene. The new video, which was turned over in October of 2024, as well as in January 2025, more than 2.5 years after they had been recorded, and months after Reed's first murder trial had ended. Some videos obtained by Reed's team in October were clarified versions of what had previously been provided, and the original videos were extremely dark. There was no apparent chain of custody for the new videos provided in October, but there was a note from the Canton PD chief, Helena Rafferty, that read, "This is how it records, LOL. No tampering." Rafferty is on the witness list for the second trial, and while Brennan conceded that the video situation should have been managed just a little bit better, he said the defense had not specifically requested that particular footage and that there was nothing to indicate that it was exculpatory, obviously going to help Ms. Reed. The judge sided with the prosecution and denied Reed's request for an evidentiary hearing on that particular issue. Now, Reed also gets to confront the people that she's accusing of framing and actually committing murder, including the former Massachusetts State Police trooper, Michael Proctor, who led the Reed investigation and was discharged from the law enforcement agency last month. Proctor is appealing that decision, according to his lawyer, and the Massachusetts State Police found him guilty of unsatisfactory performance with violations stemming from his derogatory, defamatory, disparaging, and or otherwise inappropriate text messages he sent about a suspect in that investigation to other individuals. He was also found guilty of consuming alcohol on duty. And last month, Proctor's family, including his wife, Elizabeth, and his sister, Courtney, released a statement casting Mr. Proctor as the real victim of an egregiously false statement from Karen Reed and her defense team. They added that he had been defamed, maligned, and falsely labeled corrupt by the alleged murderer, her family, her defense team, and a mob of followers. All these statements did was put his vile behavior back in the news cycle, and he had to use 2 women to do it, Reed said. What, he can't speak for himself? She also stated, the statement also defended Proctor's text. How would you feel if the contents of your personal phone were questionably released to the public without full context? Reed, whose text messages were read aloud during the first trial, said that she found that particular statement rich. And given her experience as a murder defendant, squaring off against a biased detective, Reed now looks back at the O.J. Simpson trial going back to 1995 and looking at that acquittal quite differently. She said, quote, I felt so strongly about the prosecution and his guilt and the fact that he spent all this money and all this dream team of lawyers. They all looked like snake oil salesmen to me. In the statement, her thinking now, however, has changed a bit. I'm not saying I believe OJ was innocent, but I believe that it was not a completely above-board investigation. Now that I'm smarter, I would have cheered at that acquittal. You have to hold cops accountable, Miss Reed says. Now, Reed is also expected to face other people she's accused of framing her, including Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert. All 4 have denied any involvement in the death of O'Keefe's death or any cover-up. The judge has furthermore put parameters around Reed's third-party culprit defense, banning any mention in Reed's team's opening statement and prohibiting Reed's lawyers from pointing to Colin as a suspect. Now, the prosecutor, Mr. Brennan, announced that he had permission to reveal that there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It's closed. It's over. Move along. So obviously the prosecution put that out there and the U.S. attorney put that out there. I mean, I'm sure U.S. attorney just wants to say it's over with, but it goes to show that the allegations that were supposedly being investigated based upon the first trial turned out to be a big nothing burger. Anyway, hopefully we'll get those 2 jurors next week and we start rolling straight into evidence. And hey, that's only going to take the next 6 to 8 weeks, ladies and gentlemen. Next on the docket, Lori Vallow's trial continues. Well, the Lori Vallow trial continued yesterday, and to say that it was a clusterfuck would be an understatement. Lori Vallow's brother, Adams Cox, described how Charles Vallow had grown increasingly alarmed by Lori's religious beliefs, including claims that she was becoming an immortal and that Charles was possessed by an evil spirit named Ned. Adam flew to Phoenix back in July of 2019 to help stage a kind of intervention, but said Alex Cox, who had agreed to host him, suddenly stopped responding. The next day, Charles Vallow was dead. And in fact, her brother stated that there's no doubt in my mind that they killed him. Serena Sharp testified that she attended 2 spiritual gatherings with Lori Vallow in late 2018 and early 2019. And during these events, Sharp stated that the defendant expressed spiritual beliefs inconsistent with mainstream LDS doctrine, including a claimed lack of need for repentance. Sharp further testified that the defendant led a group prayer effort intended to expel an alleged evil spirit from Charles Vallow, whom the defendant described as being possessed and dark. And finally, Kay Woodcock, a friend of the show, and I'm not sure if she's still a Patreon member or not, but she's called in on our live show a couple of times over the years. Kay Woodcock, the younger sister of Charles Vallow and the grandmother of Charles and Lori's adoptive son, JJ, testified regarding the timeline and the deterioration of Charles and Lori's marriage. She stated that Charles expressed concern for his safety back in early 2019 after the defendant, Lori Vallow, abruptly left for an extended period. Woodcock testified that she learned as of Charles' death through a Google search 2 days after it occurred. She further stated that Lori had Charles cremated and shipped his remains to her office. Woodcock also confirms that Charles changed the beneficiary of his life insurance policy from Miss Vallow to Miss Woodcock in early 2019, and that the defendant later acknowledged this change in a text message in a text message expressing frustration with Charles' move. Christine Atwood discussed several meetings with Lori and another woman during which Lori expressed concerns about Charles being possessed by dark spirits. Miss Atwood described a particularly disturbing conversation during a June 2019 gathering when Lori's brother Alex Cox reportedly said he wished he could kill Charles. Atwood also shared that Lori had mentioned casting out dark spirits from Charles and even drugging him with JJ's medication. Ooh. See, when you start getting into weird stuff, man, and something happens, it just makes you look weird, right? I think I told you I did this kind of cult thing where a couple of kids died years ago. It was a month trial. And it's just all these weird religious things that, hey, it's America. You can believe in whatever you want, right? It's called freedom of religion. But if it just sounds so wacky, people think you're crazy. You're crazy, and you let weird stuff happen. It's weird. Next, the Menendez brothers. That's right, the brothers that won't go away. 3 decades after their conviction of committing the murders of their parents, Eric and Lyle Menendez's case is making its way back into court again. The Menendez brothers aren't obligated to appear at the hearing scheduled to begin at 10 a.m. today, as long as they have legal representation present. We'll see if they're going to be there. I would think they would, and it's all regarding the resentencing. So back in 1989, for those who don't know, the brothers were found guilty of murdering their parents in Beverly Hills and were sentenced to life without the possibility of parole. Within the last few years, though, there's been a big movement, especially by their family, to get them resentenced, which would get them out of prison and possibly on parole. Now, the former Los Angeles County District Attorney, George Gascon, who is a terrible DA, I might add, supported the resentencing. However, the new district attorney, a guy by the name of Nathan Hochman, doesn't support this resentencing. Anyway, Friday's hearing centers around the document that the then DA Gascon submitted to the court, asking them to resentence the brothers. Hochman wants the document rescinded, and that's what the judge will hear argument about today. In a separate and completely unrelated hearing, the parole board is analyzing the case that took place some 3 decades ago, and basically to see whether the brothers should be released from prison. They'll make their recommendation to the governor so he can decide, the governor can decide whether he's going to issue clemency to the brothers. Now, the district attorney, Mr. Hochman, says the brothers haven't shown remorse and continue to lie about what happened back in 1989. Specifically, the DA says, in looking at then whether or not the Menendez have exhibited the full insight and complete responsibility for their crimes, they have not. Because when we outline this in 20 different lies that they have told, they've actually admitted to 4 of them, but 16 lies remain unaccounted for, the DA said. So, needless to say, usually when you get some clemency, you either say, hey, I'm totally innocent, or I was wrong what I did. The brothers, obviously, their second trial, they didn't get all the stuff about the sexual abuse allegedly performed by their father, et cetera, et cetera. Still not a defense to murder. That's why it was excluded in the second trial. But it was pretty cold-blooded. I don't know. Is 30 years enough time for somebody to serve in prison? I don't know. Let me know in the comments. I mean, I have clients that I don't think deserve to spend life in prison. And 20 years is a long time. Think about all the things. 30 years is even a longer time. Think about all the things that you've done over the last 30 years, if you're even that old. And to say they spent that much time in prison, it's harsh. It's tough. Don't get me wrong. There are some people that are just dangerous to the community, and they should be locked up for the rest of their lives. But maybe not everybody else. Hopefully that's what the legislature is supposed to let us know, and the judges are supposed to, make that independent decision if they believe it's appropriate or they're not limited by mandatory minimum sentencing. Next, this day in legal history. On this day, October 11th, 1865, President Abraham Lincoln delivered his final public speech advocating for Reconstruction policies, including voting rights for the freed slaves. Obviously, this set a legal precedent for the post-Civil War rights legislation. And on this date in 1890, Ellis Island designated as an immigration station. Obviously, Hundreds of thousands, if not millions of people have passed through there on their way to the United States. And then on April 11th, 1890, Congress designated the Ellis Island as a federal immigration station, establishing legal protocols for processing millions of immigrants and shaping U.S. immigration law enforcement. On this day in 1991, Iowa imposes the first state cigarette tax. If you want less of it, you tax it. If you want more of it, you subsidize it. Apparently, even back in 1921, the sin tax, as they were often referred to. Anyway, that was a big milestone in the public health regulation that set a precedent for state-level sin taxes and anti-smuggling laws. And on this date, in April 11th, 1968, President Lyndon Johnson signed the Civil Rights Act of 1968, often referred to as the Fair Housing Act. That was the amendment to the landmark 1964 Act prohibiting discrimination based upon race, religion, or national origin in the sale, rental, financing, or advertising of housing. And then in 1956, going back a little bit, the civil rights movement gains momentum. On that date, a federal court ruled against segregation on Montgomery, Alabama buses, a key legal victory for the civil rights movement, reinforcing anti-discrimination laws post-Brown v. Board of Education. And on April 11th, 1961, the trial of former Nazi Karl Adolf Eichmann began in Jerusalem. Now, during the Holocaust, Eichmann was responsible for coordinating the deportation of Jews from Germany and occupied Europe and concentration camps and extermination camps in Eastern Europe. In 1961, he was captured in Argentina by Israeli commandos and returned to Jerusalem for trial. A panel of 3 Israeli judges found Eichmann guilty on 15 counts, including crimes against humanity, crimes against the Jewish people, and membership in an illegal organization under Israel's Nazi and Nazi collaboration laws. He was executed by hanging on May 31st, 1962. And finally today, our dumb criminal of the day. What do I always say? It's the defendant's own words that gets them. Well, a Minnesota woman confessed in her personal journal that she, quote, totally stole a car today, end quote. Well, she ultimately pled guilty to that felony charge. Vanessa Guerrero appeared in court and pled guilty to receiving stolen property in connection with the theft last year of a 2004 Freestar van. Ms. Guerrero's sentencing is set for later in July, and a pre-sentence investigation report was ordered by the judge. Ms. Aguero looks at spending up to possibly 5 years in prison, as that's the maximum sentence. But apparently during an auto theft investigation, police were determined that the stolen van worth $2,000 had been sold for scrap by Guerrero at the in Blue Earth County, which is apparently a city where she resides in the city of Mankato. Witnesses at the auto salvage business stated that Guerrero had brought the van in and sold it to them. During the police probe, investigators were able to locate a journal belonging to Ms. Guerrero, which contained the incriminating entries. Remember what I say is anything you say can and will be used against you. Anyway, this all took place on the same day that the Ford owners discovered the vehicle missing. Guerrero wrote, totally stole a car today. Something I never thought of doing. Effing super freaking out about it. Guerrero denied knowing that the vehicle was stolen when she was first confronted by the police. Police obtained the journal from Guerrero's mother, with whom Guerrero and her boyfriend had once resided. Ms. Guerrero, you are a dumb criminal of the day. Yes, ladies and gentlemen, journals can be used against you as long as they can prove that you wrote it. It's always the defendant's own words that get them, just like Ms. Guerrero. Her own words got her. All right, that's all we have for today, ladies and gentlemen. Hope you enjoyed the show. Thanks for watching. We'll see you next time, and remember, the Constitution matters.